This is a video for my civil procedure students walking through some pointers on how to approach the MPT style writing exercise that you were given earlier this semester, which was an opportunity to practice applying the concepts we had been discussing in class on related to amendments to pleadings. So this lecture will contain my general feedback on how best to approach this type of writing exercise, where identification of the issues and walking through what a good answer might have looked like, and then provides a rubric for both a self-assessment where you will analyze your own work and then swap your paper with a partner and analyze your partner's work as well. So the assignment that you were given was a timed writing assignment where you were given a packet of information, and the packet contained a file and a library. And this is just the kind of format that you will see when you take the bar exam, if you take the bar in one of the 40 states, including Georgia, 40 some odd states, that includes the multi-state performance test as a part of the bar exam. And what the performance test is designed to do is to test your ability to analyze a new set of facts and a new set of relevant law that pertains to those facts, and to produce a lawyer-like work product in a short period of time. So the MPT is 90 minutes on the bar exam, and you have that amount of time to read and dissect the packet containing the file in the library, and to produce whatever work product you are asked to create there. So the first key task in attacking an MPT would be to identify what it is that you are being asked to provide or to prepare. And so in this case, on the very first page of the MPT packet that you were given, it said that you were being asked to create a memo. And it says specifically, and I quote, "I need you to write a memo analyzing any potential issues we may face in trying to amend Pedro's complaint." So that memo to you, the student, that came from the partner in the hypothetical firm that is handling this lawsuit on behalf of Pedro. And Pedro was the plaintiff, and he was injured in a bar fight. And he has just found out that the person that he sued as the defendant was not actually the one who was likely to have caused him his injuries, that it was somebody else. So the question is, can Pedro amend his complaint at this time? So after you've identified that it's a memo you need to write, then you needed to go through the file to identify the key facts. And there were a couple of documents there from which you could extract those facts. First was a deposition transcript from the deposition of Dante, the defendant. And it stated that the fight took place on December 3rd, 2010, and he admitted to being present for that fight, but he said that he was not the one who hit Pedro, the plaintiff, and that instead it was Albert, another person who was participating in the fight, who hit Pedro. And importantly, for our discussion of relation back, which we'll come back to in a moment, Dante, the defendant, told Albert about the quote-unquote bogus lawsuit in March of 2013. So those were key facts that you needed to identify there, among others. In addition, the file also contained a file memo from the lawyer's office where you are working, the law firm that's handling or that's representing Pedro, the plaintiff in this lawsuit. And it contained additional key dates pertaining to the events underlying the lawsuit, the filing of the lawsuit, and the dates on which the information was learned that Dante was perhaps not the one who should be named as the defendant, that instead it was Albert. And from that, you could ascertain, especially by creating a timeline, that it had been more than 2 years between when the fight took place and the present date, which was the date the assignment was given, which was in February of 2014. So then you would, with those facts in mind, you would go to the library and read the law, which the first item in the library was Federal Rule of Civil Procedure 15, which you were already familiar with, fortunately, from our discussion of it in class. Then there was a statute of limitations from the jurisdiction, which stated that the time for filing the sort of claims that Pedro had filed was 2 years. And because you have the facts in front of you from the file pertaining to when the underlying incidents occurred and when the lawsuit was filed, you know that this then creates a statute of limitations problem, so that you can see, because of your understanding of how amendments to pleadings work, you know creates a particularly hairy issue for seeking leave to file an amendment to the complaint. The library also contained cases, and you should then have read those cases with an eye toward how amendments are treated. And the cases, of course, are chosen in such a way as to give you important feedback about how the amendment should be treated under the governing law in that jurisdiction. So within the cases then, there were 2 cases there. So one was Watson versus Williamson, which addresses mistake under Rule 15. And it says a couple of key points. The 13th Circuit, where this hypothetical jurisdiction is located, has repeatedly held that a plaintiff's lack of knowledge about a defendant's identity is not a mistake within the meaning of Federal Rule of Civil Procedure 15C. And goes on then to distinguish Krupski, which was the case we had discussed in class, where the plaintiff always meant to sue the company that owned, operated, managed, supervised, and controlled the ship. And so you were to notice then from that governing law that this is a case that's more like Watson, where lack of knowledge about a defendant's identity is the kind of mistake that the plaintiff had apparently made. That this is not necessarily the same kind of mistake as in the Krupski Supreme Court case, where the plaintiff had simply sort of misnamed or named the wrong corporate defendant. The other case that was contained in the library was Addison versus Reitman Blacktop. And the Addison case contained some helpful sort of basic information about how courts should approach motions to amend, and included discussion of the Foman factors, which we had also discussed in class as the governing factors that pertain to any amendment that is filed after the time when amendments can be made as a matter of course, so that if the amendment is sought after that very initial period at the very beginning of the lawsuit when amendments can be made without permission or consent, then the Foman factors will govern, which would include delay, undue delay, bad faith, dilatory motive, failure to cure deficiencies by amendments previously sought, and futility, among others, and prejudice. Prejudice was the factor we had spent a lot of time talking about in class, which was an issue in the Beek versus Aquaslide case. So it was helpful. The Addison case was helpful for its discussion of the Foman factors generally. It discussed delay and the fact that delay alone, or that delay is not undue where a whole year has elapsed from the filing of the lawsuit initially, but the parties were engaged in motion practice during that time. So that there were things going on. It wasn't just that the plaintiff was sort of dilly-dallying, so to speak. And also said that delay alone is not sufficient to deny the motion without evidence of bad faith. And that may be an especially helpful fact for your client Pedro here, because it has been more than a year since the lawsuit was filed, but during that time the parties were litigating the defendant's motion to dismiss, and that was pending for a while, so there was little need to focus on and press forward in the case while that motion was pending. And once that motion was denied, the parties moved forward in a relatively diligent fashion to the discovery phase, and the deposition of Dante was taken, and it was only a month or a little more after that before the amendment was sought. That is the issue presented here. So all of that then could be gathered from the Addison case. And importantly, the Addison case explains that an amendment is futile as futility is relevant under the Fomen factors if the claims would be barred by the statute of limitations, and that where the claims would be barred by the statute of limitations and there is no relation back under Rule 15C, then the amendment would be futile and there's no need to press forward with it. The case also explained that mistake under Rule 15C for purposes of relation back includes an improperly named corporate defendant, which is less relevant here. And of course, there are going to be things in the library on an MPT that are not directly relevant, but you have part of the task for you is to be able to identify what those things are and parse out the particularly relevant points. So from there, you needed to then identify what the key issues were in this problem. And I think there were a few others that you could have discussed as well, but to me, I think the key ones were first, whether there had been an undue delay between the time of filing the lawsuit and the time that this amendment was sought. And as I just pointed out in discussing the case law, the Addison case contains some helpful law on this point that you'd want to be sure and point out in your memo, that 1 year of delay may not be undue if the parties were engaged in motion practice and there was no evidence of bad faith. Here it had been more than 1 year, but during that time the jurisdiction motion was pending and discovery began and the amendment was sought less than 2 months after the plaintiff learned about Albert during Dante's deposition. The second issue, which was definitely the bigger issue, was whether the amendment would be futile at this stage. And that then, because you recognize that the amendment is sought more than 2 years after the incident has occurred, and it is an amendment that would name a party who was not previously named in the lawsuit, you know then, between our discussion in class and from the case law contained in the library, that relation back is an issue and that the amendment will relate back only if the standards of Rule 15C1C are met with regard to changing the party who is named as a defendant. And so under that rule, you have to identify, or the standards as we've seen them before in our discussions are, that the amendment asserts a claim that arose out of the conduct, transaction, or occurrence set out in the original pleading, and that within 120 days from service of the complaint initially, the party to be brought in both had the requisite notice of the suit and knew or should have known that, but for a mistake, the suit would have originally named him. So that's where the facts about what Dante told Albert, that's where those facts are particularly relevant. You need to know when they were, when that conversation took place to determine whether it's within 120 days from the original service of the complaint. And you also need to know what it was that Dante said to Albert about the lawsuit. Was it enough to give him sufficient notice to allow him to defend the suit and to know that he was the one who should have been named in that complaint initially? And importantly here, as we've identified previously, the Watson case said that mistake does not encompass a plaintiff's lack of knowledge about identity. So that's going to be a big hurdle for the plaintiff to overcome here. At that point, you were ready to begin writing, and I think there were just a few key points here that I want to point out as general feedback, having looked through a number of the responses that were submitted to this assignment. One is to make sure, and this is universal for any MPT style assignment, that you're adhering to the format that was requested. And so you want to make sure in this case it was supposed to be a memo to the partner in the firm. Some of you just submitted sort of an essay style response, and that will make you lose points on the MPT. You've got to show that you can read the directions and can respond accordingly. Secondly is organization, and I think organizing around the governing rule of law in a problem like this can be especially helpful, which here was Federal Rule of Civil Procedure 15, because that would, if you then use sort of the structure of Rule 15, you've got the Fomen factors, and then you've got the concept of relation back, which the Addison case tells you becomes relevant with respect to futility, then all of that gives you a very clear and cohesive structure to use to organize your response. You need to make sure that you use facts from the file and that you use law from the library. And many of you did this, but some of you just sort of alluded to the law and never referenced any of it. But in an assignment like this where the law is provided in the packet for you, I think it is a good idea most of the time to include citations to that law, even if they're not formal, blue book style citations, but to show that you understand that this is the governing rule of law and this is the source where it came from. And that's sort of contrasted with other types of essays that you might write on a bar exam, where citations probably would not be needed. I think on an MPT type essay, citations to the law are probably more relevant. And then, of course, for any type of legal writing, the core of it should be your analysis. And that's where many of you were weakest, was in your ability to, many of you identified the key issues, were able to at least reference, if not fully state and cite to the governing rules of law, and maybe could talk about some of the relevant facts, but the analysis is where most of you need more work, and that's the case on most any legal writing that I get from you. So always know that you can work on developing your analysis more. So what I need you to do now is to go back to your own assignment and do a self-assessment. And here are some of the things that you should look for. 1, did you follow the directions and write a memo as was requested? Now, some of you did, and some of you did it in a more formal way than others. And I think the extent of the formality is somewhat flexible. I didn't feel like there was, I needed to have the very traditional question presented and statement of facts and so on. Although some of you did that, and I certainly thought that was fine as well. But certainly, at a minimum, it should look like a memo. Secondly, did you identify and organize around the issues that arise under Rule 15? Did you identify undue delay as an issue? Did you identify mistake of identity for purposes of relation back as an issue? And of course, the latter of those, as I said, is probably the biggest issue in this case. Is there going to be a way around the statute of limitations problem and the futility of the amendment that goes along with it? And did you make effective use of the law in the library? As I said, I think citations would be helpful on an assignment like this, or are necessary. And then did you rely on key facts from the library, and did you analyze the issues fully? Always look for more analysis. Finally, and this is, I think, maybe the most important part, what could you have done to improve your work product? And that's what I really want you to spend a little bit of time thinking about as you go back and look through your assignment in light of the information I've provided here. Second, then after you've done your own self-assessment, I'd like you to find a partner that you can feel comfortable working with, trade papers, read each other's papers, and provide a little feedback to each other. Did your partner follow directions to draft a memo? Did your partner identify and organize around the key issues under Federal Rule 15? Did your partner cite appropriately to the relevant law from the library? Did your partner utilize the key facts? And finally, some good sort of broad brush questions at the end. What did your partner do better than you? Did your partner maybe do a better job of analysis? Did your partner do a better job of formatting and organizing their response? Try to identify at least one thing that your partner did better than you, and one thing that your partner could do to improve. And I think it would be certainly most helpful if you all would share that information with each other. Talk about what you think each other did well and where you think maybe you could improve. And that process, I think, will help you both to learn about and understand the assignment better. So what I want you to prepare to provide back to me is a response to the self-assessment exercise, which may include answers to any of the following questions, or any of the questions I posed here, but must include identification and discussion of at least one thing you could have done to improve your paper, identification and discussion of at least one thing your partner did better than you, and identification and discussion of at least one thing your partner could have done to improve his or her paper. And you don't need to identify people in these papers that I want you to prepare. In fact, I would prefer that you not use names. So, just refer to my partner or give them a fake name or whatever it is that you want.